the very first amendment after the Bill of Rights was designed to overrule a U.S. Supreme Court decision. So if you were a court watcher of those days, you had to be worried by the fact that, at least as far as the citizens of the United States were concerned, in the court's very first major decision in interpreting the U.S. Constitution, the court got it wrong. Illustrating the distinct prospect that the court would essentially never amount to anything, the very first Chief Justice, John Jay, resigned his position as Chief Justice in order to run for governor of New York. Another early justice, John Rutledge, resigned to become Chief Justice of the Supreme Court of South Carolina. So you may wonder, well, what moved the U.S. Supreme Court from this relatively low-level entity with little business and not very much of a good reputation to the key place it has in today's system and in public discourse? And I think that if you had to attribute it to one cause, it would be the case of Marbury versus Madison. Everybody's heard of Marbury versus Madison, right? Marbury versus Madison has a number of distinctions, including the fact that a key quotation from John Marshall's decision for the court in the 1803 decision of Marbury versus Madison is engraved in gold on the walls of the Supreme Court building. And that quotation, in case you can't read it, it says, "It is emphatically the province and duty of the judicial department to say what the law is." So why is Marbury so important? Well, the answer is that in that case, the court announced that it had the power to review the legality of decisions of both of the other branches of the federal government. It could review acts of Congress to decide whether they were constitutional, and it could also review actions of the president and his or her agents to ensure that they stayed within the law. And indeed, on both counts, the court decided that the other branches of government had acted illegally. The President's Secretary of State had acted illegally by withholding a Justice of the Peace Commission from Mr. Marbury, and Congress had acted unconstitutionally by conferring on the court power to decide Marbury's case, which in fact the court ended up deciding it didn't have after all. So since then, the court has regularly exercised its asserted power to review acts of Congress to determine whether they're constitutional, as well as acts of the president. Perhaps the most famous decision invalidating an action of the president was the court's decision in 1952 invalidating President Harry Truman's attempt to have the federal government take over the nation's steel mills to keep them operating during the Korean War, despite a labor dispute involving the steelworkers. Today, of course, we continue to take for granted the court's power to review actions of the president. So just last term, the court reviewed President Trump's so-called travel ban, upholding it by a narrow margin, but no one questioned the court's power to review what President Trump had done. And so, too, the court has regularly exercised its power to strike down acts of Congress. One of the more recent examples occurred in 2005 when it struck down an act of Congress that restricted the ability of suspected terrorists detained in Guantanamo Bay Naval Base to get judicial review of their detention. Congress set up this elaborate administrative mechanism providing for what were essentially military commissions to review detentions of the suspected terrorists. And the court struck it down on the grounds that it invaded the privilege of habeas corpus, which is protected by the Constitution. And of course, in a case actually decided shortly after Marbury versus Madison, the court also decided that it had the power to review actions of the individual states. And that is a power that it has continued to exercise since then. Recently, for example, a few years ago, striking down state laws that prohibited same-sex marriages. So, indeed, Marbury versus Madison was the milestone case establishing the court's power. Though it is worthwhile actually noting this precise wording of the quotation from Marbury versus Madison on the walls of the Supreme Court. It is emphatically the province and duty of the Judicial Department to say what the law is. Well, it's one thing for the court to say what the law is, but it's quite a different thing for people to hear and to accept what the court says. And that leads to, hopefully, that will lead us back to the importance of public perception of the court's power and its legitimacy. But this issue of the relative vulnerability of the court and really its dependence on its perceived power was reflected early on. I'm quoting now on this next slide a quotation from the Federalist Papers, Federalist number 78, written by Alexander Hamilton. And he said that the judicial branch of the United States will be the least dangerous of the three branches. Quote, the judiciary has no influence over either the sword or the purse. And of course, the reference to the sword indicated the executive branch, right? That literally fights wars and can call out the military. And the power of the purse, of course, refers to Congress, which ultimately controls federal spending and collection of taxes. In contrast, the judiciary has no direction either of the strength or the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment. And indeed, that does mean that the court's power depends a lot on public perception of its legitimacy and its power. And that its inability to enforce its will directly is illustrated by a famous case called Worcester versus Georgia. This is an 1832 case. In 1832, the Cherokee Indian tribe lived on land that was guaranteed to them by treaty. Well, they found gold on that land, and Georgia then tried to seize the land, sending its own citizens to settle in and mine for gold. The Cherokees brought an action directly against the state of Georgia. There's Georgia again, in a U.S. Supreme Court case. And the U.S. Supreme Court ruled in favor of the Cherokees. Georgia then refused to obey the court's judgment. And President Andrew Jackson took no action to bring in federal authorities to help enforce the judgment. President Andrew Jackson reportedly said, John Marshall has made his decision, now let him enforce it. And indeed, President Jackson would ultimately send troops not to enforce the judgment, but to evict the Cherokees, who traveled what is called the Trail of Tears to Oklahoma, thousands dying along the way. All of this is to say that the court's power depends partly on the perception that it is indeed supreme, that it is objective, it is above the fray, and it is a body that bases its decisions on law rather than politics. And so public perception is particularly important because public perception puts pressure on the political branches, namely the President and Congress, when it comes to how they treat the court's decisions and the court itself. This also is further illustrated by the defeat of President Franklin Roosevelt's famous court packing plan. How many people have heard of the court packing plan? Just when you thought the idea was dead, apparently some people now are starting to talk about the idea of packing the court. Well, so FDR, of course, devised his court packing plan because the court had struck down several acts of Congress establishing the major components of FDR's New Deal. So under FDR's court packing plan, the number of justices on the court was to be increased in a way that was tied to the age of the existing justices. Remember, he referred to them as kind of a horse and buggy court, applying old law instead of modern law. So this debate about the nature of the Constitution and whether it's a living or a dead document has a long pedigree. So FDR's plan would automatically have allowed him to appoint 6 new justices for a total of 15 that would have enabled him to garner a majority of justices favorable to his New Deal program. Now, one of the reasons that FDR's plan failed, it's a complicated history and I don't pretend to be an expert, but one of the reasons it failed was negative perception of FDR's cynical plan. No one believed FDR's ostensible reason for the plan. He justified the plan as these justices are getting old and they need help and they're frail and there's so much business on the court. They really need some fresh blood to help them keep their docket timely. No one believed that. Probably, certainly not FDR and no one else. And so the negative backlash to that cynical plan partly was what defeated it.